Hello, my name is Šimović. I'm an associate professor at the University of Zagreb, Faculty of Law, Department for Family Law, Croatia. First of all, I would like to express my gratitude to the organizers of the conference. It is, as always, a pleasure to be here in Budapest. The topic of my presentation, here we go. The topic of my presentation is participation rights of the child as prescribed within the UN Convention on the Rights of the Child. Just a few introductory notes about the Convention on the Rights of the Child. So as we all know, it was adopted by the UN on 20th November 1989. And the CRC is truly a global international treaty due to the fact that it was, as Professor before me said, ratified by all countries of the world except the United States of America. Family law theory considers it to be the clearest and fullest statement of children's rights, but the 1989 text cannot be regarded as definitive because of the rapid social changes happening in the world. So for this reason, the family law theory poses a question whether is the text of the CRC ripe for revision. The contemporary perspective in international legal literature is that participation rights encompass, first and foremost, the pivotal right of the child, and that is the right of the child to express his or her own views freely in all matters that affect him or her, as prescribed in Article 12 of the CRC. There are three other significant participation rights, one of which is the right of the child to freedom of expression. This right is particularly important because it includes the freedom to seek, receive, and impart information and ideas of all kinds and in all forms. More importantly, this right is very much interconnected and interdependent with the right of the child to freely express his or her own views, because the child has a right to be informed and has a right to obtain advice in a child-friendly manner before eventually deciding whether or not to express their views in, of course, all matters that affect them. Last but not least, there is the right to freedom of thought, conscience, and religion, and the right to free association and peaceful assembly as prescribed in Articles 14 and 15 of the CRC. These articles are crucial for the visibility of the child and for the respect of the child as an active subject and not a passive object of the law. Legal theory considers that the child gains visibility while through the realization of his or her participation rights. What does this mean, visibility? It means first and foremost visibility of the child within the family, visibility of the child within the society the child lives in. And this means that the views of the child need to be taken into consideration when parents, for example, or policymakers are deciding upon issues that are of relevance for the life and interests and rights of children. For example, educational issues, for example, environmental issues, healthcare issues, nutrition issues, play, recreation, sports, and so on. This is the first part of visibility of the child, of the children. And the second part is, of course, visibility of children as active subjects, as active participants in all administrative and judicial proceedings in which their interests and rights will be decided upon. Children are the sole holders of participative rights, which belong to them unconditionally in all areas of their life. This means that parents are not holders of these participation rights of children, but they do have a position of utmost importance because they need to help children in exercising those rights in practice. The provision of Article 12 reads as follows. State parties shall assure to the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. So it seems to me that this provision provides an answer to a lot of questions. For example, to whom shall state parties assure the right to be heard? So it is obvious that the Convention doesn't answer to all children, but only to children who are capable of forming their own views. Another question is, how will children express their views? And the answer is all children have the right to express those views freely, meaning without undue pressure, without manipulation by parents or family members or third related or unrelated persons, or without being in a position of conflict of loyalty. State parties have an additional obligation to help children express their views either directly or through a representative, objective and impartial representative, or an appropriate auxiliary body. Last but not least, there is the question of the impact of the views of the child. So the views of the child will be given due weight in accordance with the age and maturity of the child, which is the concept of evolving capacities of the child. This means that as the child grows older and matures, the impact or the weight of his or her views on the decision-making process will increase. This impact is not without limitation. The European Court of Human Rights has concluded in several occasions that the impacts of the child's views on the decision-making process has its limits. For example, in the case of KB and others versus Croatia, the European Court of Human Rights concluded that the right of the child to express his or her own views should not be interpreted as effectively giving unconditional veto power to children without any other factors being considered, for example, the best interest of the child. Committee on the Rights of the Child concludes that Article 12 is the fundamental value of the CRC, concludes that Article 12 is not only the right of the child, but one of the four general principles for the interpretation and implementation of all other children's rights. At the end of my presentation, I would like to address one more issue, and this is the issue of interconnection and interdependence of Article 12 and Article 3. So Article 3, of course, the general principle of primary protection of the best interest of the child. The standpoint of the family law theory is that if the child opinion is not established because he or she was not given the opportunity to express his or her own views, considerations, thoughts, wishes, then the child cannot be protected because it will be impossible to determine what is the child's best interest and how to protect it. So in a way, proper application of Article 12 is like a hallway leading to adequate application of Article 3 of the CRC, or in the words of Michael Freeman, to protect the best interest of the child is a mirage without knowledge of the child's perspective. Thank you very much for your attention.